services. These are mostly probably due to security. The taxation on cannabis right now, because banking is challenging for the cannabis business, taxes are basically paid in cash. So there has to be, as you can imagine, quite a bit of security on the days that these taxes come in to whatever designated spot they get paid. So we're assuming that an independent security company would need to be hired to provide the safety and security for those tax payments. So as you can see, and these are first year costs, we're anywhere from $600,000 to almost $1.2 million annually. We applied inflators to these amounts each year, knowing that staff costs do increase over time. So this chart depicts what the average costs over the 10-year period are under each scenarios. Again, they're very similar to the numbers I just said, $600,000 to $1.2 million annually. So that brings us to net revenue. So we take our gross revenue minus our costs, and this is what would be projected to go to the city's general fund after costs are taken care of. Under scenario A, it's anywhere from $800,000 to $2.2 million. Scenario B, 2.5 to 6.3 million, and scenario C, 3.3 to 11.6 million. This chart just summarizes, because I know we're throwing out a lot of dollars and data points here. It just summarizes the net revenues, both annually, over 5 years, and over 10 years. I won't go through each box, but maybe highlight the 10-year totals. Under scenario A, anywhere from 8 to 22 million. Under B, it's 25 to 62 million. And C, it's 33 to 116 million. So that's the total net revenues combined over 10 years. The second part of our report dealt with the economic impacts of cannabis businesses potentially in the city of Hemet. And for this, we use the in-plan economic model. It's really the industry gold standard of economic modeling. The University of California study used it, as well as a number of other studies that we reviewed. Generally, in the area of economic analysis, this is what is best practices. So the in-plan model looks at 3 different types of effects. The direct effect, which is the production and expenditures by the producers and consumers as a result of an activity or a policy, in this case, the potential for legalizing cannabis in the city. The indirect effect is the impacts of local industries buying goods and services from other local industries spurred by the economic activity of cannabis businesses. And the induced effect is really the respending of income that's generated from the economic activity. The first part that we looked at in the economic analysis was the creation of new jobs. So this would be direct, indirect, and induced. So that means these are not just jobs that would be created by the cannabis industry. These are jobs that would be created by that industry plus all the other businesses that would serve that industry. And this is limited to just the city of Hemet. So this isn't regional, it's not county-wide. This is just within the city limits. So under scenario A, it would be anywhere from 117 to 344 jobs. And these jobs would actually be created the first 2 years after all the businesses had opened. So it wouldn't take 10 years to generate the jobs. Under scenario B, it'd be 300 to almost 900 jobs. Scenario C, anywhere from 350 to upwards of 1,400 new jobs created. With regard to economic output, and again, that's the value of goods and services in the example, because I know that's kind of a vague term. Say that someone bought $100 worth of wood from a sawmill and then created from that wood a piece of furniture that they then sold for $300. The total economic output for that end product is $400. The $100 with the wood purchase, the $300 with the furniture purchase. So that's really what this represents here. So in terms of economic output for scenario A, $21 million to $57 million, and this is over 10 years. Scenario B, it would be $42 million to $120 million. And then scenario C, again, the least conservative, is $56 million to $227 million. And here, I won't go through this table, just sort of to look at the jobs and the economic output side by side and together. And we are available to answer any questions that you might have. And if I could maybe quickly answer Councilmember Meyer's question about how other cities are dealing with the cost of shutting down illegal dispensaries. The cities that have legalized cannabis, either just medical or adult use and medical, are using the revenues from the taxes that they levy to help defer those costs. That's really the plan that's happened. The other thing that we understand just from our research and talking with people in the industry is that once legal, legitimate cannabis businesses move into a city, they are very watchful for those illegal shops because they really don't want those illegal shops to be there. It undercuts them, it undercuts their bottom line. So you almost have, I don't want to say a partner, because I don't know if I would go that far, but what you have is another industry who's going to alert you and probably going to do whatever they can to assist in the shutting down of any illegal businesses.
Any other questions?
You mentioned that there's state requirements that require product inventories every 2 weeks and audits. And who actually enforces that? Would that be a representative of the state agency, or would that be incumbent upon us to do through our code enforcement?
It really is the state, unless you, through your ordinance, required that. If you did not require that through the ordinance, a staff person going through the inventory records, then the city would not be responsible for doing that. And it might be duplicative because the state is already going to do that themselves. To check the records. And they might not go every 2 weeks, but they will enforce the keeping of the records.
Seems mighty ambitious that the state would undertake that to check inventories every 2 weeks. But thank you for answering.
Sure.
Any other questions? All right. Thank you so much.
So, Mayor and council members, now that we've stuffed you full of good facts and information, we've run out of time, really, for your study session, at least during your 6 o'clock hour. My presentation will take probably 10 to 15 minutes, and then we do need direction from you tonight. So you're going to have a substantive discussion because of the timing of everything. I'm more than welcome to get up and do my presentation now and go through with your discussion, or we can defer this until after your regular business meeting. It is your meeting. I'm happy to do your pleasure.
What do you guys want to do? Keep going with this or come back to this after? Okay.
Okay. So under normal circumstances, you'd be able to take all of this information, digest it over several months, have a number of public workshops, and then decide what you wanted to do, if anything. We're in a unique situation now. We have an election coming up in November, and on the ballot in November, we are going to have at least one, and still maybe two, private cannabis initiatives. I'm going to go through what those cannabis initiatives do and what they don't do briefly, but I think enough to give you the flavor of what's happening. So our situation today, as we sit here today, the city of Hemet has a complete ban on all commercial cannabis activities. I'm going to use that phrase over and over again because that's what the law uses to describe a whole variety of different types of legal cannabis activities, and that ranges from dispensaries to cultivation to manufacturing. Manufacturing, for those of you who don't know it, is really taking the cannabis plant and extracting the psychotropic elements out and then infusing them in a variety of materials, whether it's beverages or creams or other things. There's distribution facilities, there's testing facilities, there's delivery, and then a whole number of sub-tranches in between as the state has created a number of sub-licenses. But today in Hemet, all of that's illegal. We don't allow anything. No commercial cannabis activity. In November of last year, we received a privately initiated cannabis measure to go on the ballot in November. That ballot has qualified. They've collected all of the signatures. They've been verified by the Riverside County Registrar of Voters, and it will be on the ballot. We will be bringing that to you in a resolution next meeting, and it's just a ministerial obligation of the city to put it on the ballot. The city's not endorsing it. It's not the city's measure. It's just under the election code. We have to actually put it on the ballot. That measure is the subject of a lawsuit currently. In fact, we had a status conference on that lawsuit today. The other measure, what I'll call the pending measure, is also a privately initiated measure to allow commercial cannabis activity in the city. It's very similar to the first one. To our knowledge, they could be out collecting signatures. We don't know. What we know is they have not submitted their petition and any signatures to this date. Timeline is getting very short for them to do that. In fact, we might be in a position where even if they submitted all of their signatures, the Registrar of Voters wouldn't be able to go through and validate them in time for us to put it on the ballot on August 10th. The deadline for us and any of the proponents to put something on the ballot is Friday, August 10th. That's the timeline we're working with. A little bit on the legal challenge. Unless we have an order from the court that prohibits the clerk from putting it on the ballot, we will have to put this, what's called the qualified measure, on the ballot. At the status conference today, we found out that there are two real parties in interest. So when you do a measure, you have to have some people in your city sign on to be the proponents of it. Those two proponents are what are called the real parties in interest. They have to be part of the lawsuit, although the city gets named as a defendant along with the city clerk, because it's us that the court would have to issue an order against to stop us or tell us you don't have to put it on the ballot. One of the real parties in interest has filed an answer, which means the lawsuit is live and needs to be argued between them. One of the proponents has been defaulted. We appeared in court this morning on behalf of the city, told the judge, and we've worked this out with the entity that's brought the lawsuit challenging it. Although you have to name us, we're not part of this. We're not going to defend it. We expect that there will be no attorney's fees levied against us. We're not part of the argument. It's between the real party in interest and the party that's bringing the suit. The party that's bringing the suit is the party that's behind the pending measure. So they're both competing and fighting against one another. And you'll see that they're really similar in terms of what they're trying to do. As I mentioned, the last day for us or any of these other folks to put anything on the ballot is August 10th. You have a meeting on the 24th of July, and then you would have a meeting on August 14th, which is after the deadline. So if we don't make a decision tonight, you either have to make a decision and we have to have something put together to adopt on the 24th, or you're going to have a special meeting between then and the 10th. Or do nothing. That's one of your options. So let me go to the options. You really have two options because of the measures. One, do nothing. Take no position with regard to the measure. You don't have to do your own measure. And what happens? Well, if the qualified measure pass, it will partially supersede our existing ban. It will allow some commercial cannabis businesses in town, but not all. If the pending measure obtains its signatures, qualifies, gets on the ballot, and it passes by a higher vote than the qualified measure, it will completely supersede your prohibition and will allow a fuller range of cannabis businesses in town. If the city doesn't put up its own resolution, then there's nothing to compete. It will be one of these others. If they don't pass, our ban stays in place. Next option. The city can run what's called a competing measure. Now, that competing measure can be a variety of different things. I've oversimplified for the purposes of explanation tonight just the three basic choices. One, you could have a measure that would continue your existing complete ban. That complete ban would stay in place until the voters repealed it. Or you could have a complete ban with a sunset and the ban would go away at some specific time. You could have a complete ban with some type of reopener. I've just sort of flippantly said until the federal government either acquiesces to local cannabis activity or actually legalizes commercial cannabis activity in some way. The other option is for the city to actually put on a competing permitting, regulatory, and taxing ordinance that would allow some or all commercial cannabis activity in town under your chosen regulatory framework. So I mentioned that the two private cannabis measures are pretty similar. On this slide is basically what both of them do, and I have another slide that will show you the differences. They have a section with declarations and findings and definitions. They're nearly exactly the same. A few small tweaks, which I'll point out on the next slide. They both allow medical and recreational or adult use commercial cannabis activity. They have a minimal application process. It is a ministerial permit that's issued by the city clerk on a very short-term basis, and the application is very simple. You provide the name of the owner and the operator of the business, and you submit the address and APN where the business is going to operate, and if it is in a M1 or M2 zone, north of Oakland Avenue, you get a permit. That's it. It is limited to the manufacturing, that's light manufacturing, heavily manufacturing. For the first year on either ordinance, if they're adopted, the area where our commercial cannabis activity would be allowed is from Oakland Avenue north in any property that is M1 and M2. In the second year, the city council can actually expand that zone to any other M1 or M2 property within the city, but not any other zones. It imposes very minimal operating requirements on the cannabis businesses. Both of them do impose a general tax on commercial cannabis activity. These are a business license or an excise tax or not a sales tax. The city is permitted to amend essentially the measures. The measures adopt a couple different sections to our municipal code. And after 24 months, the city can freely amend those sections. Unclear at this time whether you could amend them to the extent of reinstalling your ban. That's probably not something that you could do, although you probably could limit or contract or expand the amount of commercial cannabis activity. It's an odd provision. There is no sunset provision, however. Okay, a little comparison. So the measure that's qualified, that's going to be on our ballot, does have one distance requirement. No cannabis facility or cannabis property can be within 1,000 feet of more than 3 other cannabis businesses or lots. There's no sensitive use restriction here. Into the qualified measure, it's M1 and M2 zones, but as they existed on October 6th, 2017. That means they never get to expand, contract, move anyplace else. They are, for all purposes, for all time of the measure, until 24 months go by, limited to that. In the pending measure, there's no distance limitations, and it's the M1 and M2 zone without any kind of date fixed in time. Under the qualified measure, the uses are described in our zoning code as permitted uses. That means you get a permit, they're permitted by right. Under the pending measure, they're described as AUPs. They don't really mean AUPs. In our zoning lexicon, an AUP is an administrative use permit that is issued after review and application to the community development director and some amount of hearing. What they actually mean in their initiative is the ministerial permit process with the city clerk. Under the qualified measure, dispensaries, retail sales are prohibited. They really only allow cultivation, manufacturing, distribution, and so on. The pending measure does allow dispensaries. Qualified measure simply allows the city clerk to set a reasonable permit fee. Under the pending measure, that fee is a maximum of $500 per permit. The qualified measure has a priority application process, which frankly is just monopolistic. And I say it's monopolistic because there's a priority application and then a non-priority application. If you meet the priority requirements, you get to submit your permits for a whole 15 days before everybody else does. In order to get priority requirements, you have to have a certain specific phrase written into your business formation documents that are filed with the California Secretary of State on or before October 6th, 2017, the same date as the zoning. Now, we just did a spot check. You have to actually have the name of the business when you're looking up Secretary of State's records, but we did a spot check of just various business names, pulled up 10 applications. Not a one of them have this particular phrase. And, of course, the measure isn't even on the ballot. It hasn't passed, so anybody who doesn't try to think a year ahead of time is not going to get priority status, which leads us to believe that there is one business who's going to come in and pull all the permits, and that will take up all of the available space. The challengers are making the argument that it is monopolistic, and we'll see how they fare. There is no priority application process in the pending measure. It is simply a first in time, first in right, free-for-all. The qualified measure does have a $10 per square foot tax, and generally this is what happens on large uses, cultivation uses or manufacturing uses. It's per square foot that's used for the cannabis activity, excluding office space, employee lunchrooms, break rooms, non-cannabis storage rooms, things like that. The pending measure, slightly different. It has a $5 per square foot tax, same exclusions for office space and other non-cannabis uses, but it also has a 3% gross revenue tax. Now, it doesn't say the $5 is on cultivation and the 3% is on dispensaries. It just leaves it open. It says or, so it would allow the city to choose who's going to pay what. Both of the measures do allow the city to enact regulations to help implement the measures. What they don't have much of what we see in the other communities we've worked with that have adopted what I would call rigorous but reasonable regulatory programs. No background checks are required. There's no requirement that the property owner sign or approve the application. Now think about this. When I'm going to walk in, all I have to do to get a license from the city is put my name and the address and the APN of a property. I don't have to have the property owner's signature on it. Property owner doesn't even need to know under either of these things. So I could walk in with 4 or 5 applications, identify the addresses and the APNs, and as long as it's in the M1 or M2 zone and those properties are there, I now have a license from the city. The licenses, the application processes under both of the pending measures do have weak or non-existent operating plans. There are no hour of operation controls. There are no distance requirements for what we would call sensitive uses. There is no on-site security presence or any other types of those measures, no cash handling requirements. There's no requirement for an annual review or audit of the license. They just, once it's issued, it's good unless you get it revoked. And since there are very few operating requirements, it'd be difficult to revoke one of these. The licenses are freely transferable without a background check for the new owner. All they have to do is come in, pay the administration fee or the license fee to the clerk, and they get the new license. There are also no over-concentration language. Many of these you can't have so many of these within a certain number of square feet or distance of one another, or there can't be X number of square feet in a certain area, all told. The qualified measure does have the 1,000-foot distance setback from 3 other cannabis uses, but that's that. So I mentioned one of the options other than the do-nothing approach is that the city have its own measure. One of the things the city could do is adopt a permitting, regulatory, and tax measure to allow cannabis activities, and you could base it on the poll results. Basically, that would be allowing some limited retail sales or dispensaries, but only for medical cannabis. You wouldn't allow adult use or recreational cannabis dispensaries. You would allow cultivation and manufacturing. You wouldn't limit that to just growing medical cannabis. It's very difficult to control the end users of the manufacturers and the cultivators, although the cultivators and manufacturing would not be able to sell directly to the public. It would be a wholesale to other licensed things. And then there would be a set of best practice regulations, which we would include, obviously, background checks, distance requirements. We'd limit the hours of operation, security requirements. We'd limit it to industrial or other zones that you felt would be appropriate, obviously not residential zones. And we'd probably put some type of limited feet, square footage allocation to all commercial cannabis activities. And then, of course, we would recommend that the city have a tax along with it. The tax rates, I think that the RSG report goes into pretty well, and you could see where the various spots are. I would recommend not only a per square foot tax, but also a gross revenue or gross receipts tax for the different types of uses. Some businesses or some entities do use a per gram tax on manufactured goods. I think that's difficult to administer. It's easier to do a per square foot or a gross revenue tax. The measure would need to include additional regulatory requirements, but this is just some of them. And obviously, we would try to capture all of the ones that polled very highly in pages 26 to 29, I think, of the FM3 report that John went through earlier today. That's it. I've tried to blow through that as fast as I can. I'm happy to answer any additional questions. We do need to have some discussion and direction from my standpoint. That direction can be as simple as let's do nothing, or no, we need to put up a competing measure. If it's we need to put up a competing measure, then the council really does need to give us direction, preferably tonight, so that we can bring it back to you on the 24th. If not tonight, then we're special meeting bound to honor before the 10th. With that, I'm going to sit back in my seat, and I'm happy to entertain questions. Thank you.
Any questions for Eric before he sits down?
I have a couple questions, but I'll let him sit down.
And we do have a few people that would like to speak.
Thank you for that overview. on a very complicated set of circumstances. You mentioned the lawsuit. What's your best guess on what the likelihood is that the lawsuit may result in neither one of these competing measures getting onto the ballot?
The lawsuit will only affect the qualified measure, and I think that there's a fairly good chance that a court will find that the measure does have monopolistic tendencies. There was a similar measure that was defeated in court in San Bernardino. Hopefully the court will take the same position in this case, but we're in a timing issue now. The court hasn't set a briefing schedule yet because not all of the parties had appeared and or hadn't been defaulted appropriately. The court set a new status conference for July 18th, at which time it will set a briefing schedule. That leaves less than a month for parties to brief and the court to hear and decide the matter before we're required to put something on the ballot. So I think that there is probably a less than 30% chance that we'll have an order from the court prior to August 10th. Now, I think the court and certainly the attorney who brought the suit is aware that they're going to have an order before the registrar of voters has to go to print on the ballots. I don't know that exact date. It is obviously sometime after August 10th, but I cannot remember unless the clerk knows the date of the printing. It is, I think, at least a month out from November, so it's probably sometime in October or maybe even September.
So right now, the qualified initiative, if there's no decision from the court, that one's ready to go and be on the ballot.
Correct.
So if there's no decision by the court by August 10th, that one goes on.
It will be coming to you on July 24th for a resolution to put it on the ballot. Obviously, your decision to put it on the ballot will be contingent upon what the court does, and you can always. That's why they've sued us, because if we have to put it on the ballot, our instruction will be to take it off or to take whatever action we can along with the registrar. So we'll be able to do that.
So if we put it on the ballot by resolution on July 24th, and the court says it's monopolistic, they can direct us to take it off.
Yes.
Okay. And hypothetically, if one or both of the initiatives end up on the ballot, and we add our own competing measure generated by the city, essentially there's a potential that you'd have three competing initiatives on the same basic subject.
Correct.
Not a good picture. Not a good picture. Based on the survey and how much confusion there is about marijuana legality in the city already, having three competing initiatives would not be good.
Just two questions on that. Would it be designated? I mean, if it ends up three competing initiatives, does the city initiative designate in the line explanation that it is the city initiative?
Yes.
Because that could help clarify. Jurupa Valley defeated one of these people who has been going around by doing that, by having this is a city initiative, and they passed the city initiative, which was to continue their complete ban. However, my next question is, how much does it cost us to have all of these initiatives? I mean, it's going to cost us anyway. What is the first one going to cost us?
There's no way to know that. It's going to be a citywide election as opposed to our two district elections.
Okay.
So my election last year was approximately $120,000, but there's no way to know until you know how many precincts they're going to have to set up, how many how much room it takes in the ballot.
But it could come to at least that. Okay.
We're going to have that already with the
Yeah.
one that's qualified.
The one that's
It's going to
qualified,
make it
right.
citywide already.
Right. There's no way in hell I'm going to make a decision on this tonight.
There are some people that would like to speak, so Sarah, what do you have?
Arvid Anderson, and he'll be followed by Tim McDonald, and she'll be followed by Nathan Miller. If you're ready to speak, that would be appreciated.
Excuse me, sir.
Good evening, Mayor Percival and city council members. Is this signal on?
If the green light is on.
Is the green light right there at the base?
Oh, there we go. Okay. Thank you, appreciate it. Well, it's good to talk to you again. Thank you for this time. This is a very another difficult issue that we all have to give thought to. Just like the last ones, just like opt-out, and just like districting, I'm up here again to urge you to sit and think. This isn't something that we need to jump into, because outside interests, once again, are running the show. They're driving the bus on this, and it's about money. It's not about providing medical marijuana. It's about providing profits to the distributors, the growers, and the whole system. If you don't know it by now, there already is a marijuana industry in Hemet. I have anecdotal evidence of that already, and I'm not going to go into it. This is something that needs to be thoughtfully considered. And really, what type of a city are we going to? Do we want to be San Bernardino? Do we want to be, just because San Jacinto considers this a good source of revenue, do we need to follow their direction? We need to be different. We need to be able to decide on our own, not from outside pressure, not from what feels good, or not because of popularity, but decisions are made based on facts and on values and on courage. The courage that you showed during the last squabble that we had impressed me. I was really impressed with your steel backbones, and this is going to be difficult because we're faced with these outside measures that are forcing the issue and coming to a decision on this. The question is that, do we really need a source of revenue? I mean, is that what this is about? Yeah, I know. That's a question that doesn't need to be answered. But I have a better idea, a modest proposal for you. I think that we should take all of the revenue that we potentially get from marijuana and place it in drug rehabilitation programs in this city and use it for our homeless. How about that? How about, instead of putting it on the general fund, that we use it for social issues to try to alleviate the problems that we already have with drugs. Drugs have been an issue in this city since I've been here 33 years. It hasn't changed. Why? Because we seem to be an easy mark, as they say in the business. Are we going to be an easy mark again? I hope not. Okay, thank you.
Fix the microphone. City Council, City Mayor, I'm very impressed, Alan, with the information that we received tonight. You've done a great job putting together the information so that we have a basis on which to make some decisions. I've had arthritis of the spine for a number of years and always dealt with it with aspirin. This year, it changed for me. And so I had to go on opiates, which I did not want to do. Opiates affect your kidneys, your liver. They're not, as far as I'm concerned, they're not good things to use. So I hunted down and found somebody in Riverside who is legally licensed and who manufactures cannabis oil. I haven't had a pain pill for the last 5 days. And I'm very, very impressed and grateful to be out of the pain. I don't get high. That doesn't happen on cannabis oil. They've reduced the happy grains out of it. No munchies. I think it would be a shame for the city of Hemet to pass up the opportunity to make some of the revenue, additional revenue that we need to balance our budget by turning away from the opportunity of taxing at least medical marijuana. The number of elderly people in Hemet who use pot, use the oil as I'm using it, I think is in the thousands. They flood some of the illegal dispensaries. So you can tell sometimes where those dispensaries are. They're so busy. And Hemet should find a way, and there are certainly regulations that are broad enough and specific enough to give the cities in which cannabis is being manufactured and sold, either as medical marijuana or as recreational. I don't know that our community is ready to embrace recreational. I think it needs more education. But I really recommend that you seriously consider medical marijuana licensing. Thank you.
My name is Nathan Miller. I actually live in Corona, but this issue interests me. And really, I just have a few questions, and I think it's informational, should benefit the council members as well. First one's an easy one. This is going on the consolidated, it's going to be consolidated with the general election, correct? Okay, the current qualified one. The other one, the next question is there a difference with this qualified measure and the legal challenge to it as compared to the one that you said took place, I think, somewhere in San Diego, where this seems to, the current qualified measure only affects marijuana or cannabis-related businesses that don't have any kind of retail, right? Because it doesn't. There's no recreational or medical included in the current qualified measure, correct?
Qualified measure allows both medical and recreational, but it doesn't allow dispensaries. So there's no retail sales.
Can you explain the difference there?
You can have facilities that grow cannabis in town.
Okay.
You can have facilities that manufacture cannabis products, but you can't sell anything directly to the public.
Nothing gets sold to the public.
That's
so
right.
This
So there's no cannabis store.
Cultivated, manufactured here, but sold elsewhere.
Correct.
Okay. Yeah. All right. That's what I was thinking. All right. The discussion, medical versus recreational. The speaker just before me talked about whether the city's ready for medical versus recreational, but really what it all comes down to is recreational. I imagine is going to cost a little more because there's heavier regulations involved in taxes. But really the difference between the two is that and a piece of paper that says you have a prescription, where people go to a doctor and it really doesn't take much of an explanation to the doctor to get issued a prescription to purchase whatever kind of a marijuana product you have. Has there been any consideration in the or has it ever been asked before in other questionnaire or polls, if you educate the public to that factor, does that impact whether or not they support one versus the other, or they see both differently? Just something I'm putting out there. If you do some kind of a study like that, I think it might be interesting in terms of public reaction and how that might impact what you consider going for, or the decisions you make. So with the qualified measure and some of the things that you said that it won't do, like it doesn't have background checks and stuff like that, aren't some of those things going to be mandated by the state law regardless?
The state law does require a number of different things, background checks for the holder of the license included. Typically, local governments will impose more strenuous background and criminal check requirements than are required under state law.
Okay, so there should be minimal background checks as required by the state, but because of the way the ordinance is written, it won't allow the city to do more strenuous background checks?
Correct.
Okay.
It also doesn't require the applicant to have an existing California-issued license for cannabis.
Okay.
Thank you, Nathan.
But don't they have to go through the city first before they can get a state
That
one?
is correct.
Okay.
Your
And
time,
the last one,
your
resolution
time's
on,
already expired, Nathan, but thank you.
just really quickly, it's the resolution on the ballot that you guys put. Can you include language in that resolution that automatically will cause it to invalidate if a court order is sentenced, so you don't have to take any further action?
Yeah, we can't adjust any of the terms of the ballot measure itself. Our resolution,
The resolution just
our resolution will recite that we understand that there's a legal challenge pending, and if a court order is issued, we'll take the appropriate action and follow the court order.
Got
We
it.
can't change the terms of the measure itself.
Okay, I got it. Thank you. Appreciate it.
Any more speakers? All right. Direction, comments?
All right, I'm going to talk about this. This is a topic that is, I by no means want to advocate for marijuana. But the fact of the matter is, right now we fight it every single day. And we're spending more money from the city fighting this problem than we would be if we made our own rules for it. So that's something that we really need to think about. This is, for me personally, right across Florida Avenue from my house is an illegal dispensary. It's in the county. It is running all day and all night. There are cars that are racing up and down Cornell on the south side in the county. We should probably note this for Caltrans, there are more accidents on the corner of Cornell and Florida now because they're probably driving high. There are no regulations on this building, not even the color of the roof that is neon green. And so I feel like we need to take this opportunity and put this on the ballot and make our own rules. And I know that's questionable in so many ways, but if we don't do this on our own and start letting other people decide what happens in our city, then our opportunity is gone. So, and Arvid and his grand ideas of dealing with, yes, you hit a nerve on that one. We can designate money towards rehabilitation and homelessness in our city. Because the fact of the matter is, we can go back to Valley Restart, and it costs $240,000 to take care of 226 people a year. So could we use some of that money and designate a certain amount every single year towards that? Of course we could. Could we get our roads paved? Gary's not here tonight that complained about the roads so many times, but how many roads in our town are so bad? They are. There's so many projects that our Public Works Department has been stalled on, and they need to be fixed. There's things in our city that have fallen apart because of so many budget cuts year after year after year, pulling and pulling and pulling more, and we just did some more. This is an opportunity to make our town glue it back together. You know, if you want a new face on Hemet, then we need to take some risks and do it. And I feel like this is a risk for sure. But if we can fund it in a way and make the rules so that we can enforce them, it'll make a big difference.
Any other questions, comments down there?
Can we
No, sign it.
Can we wait till the end of the meeting to give direction to staff?
Okay, all right.
I mean, we've
So
got
is-
to come back and talk about this again,
Sure.
but I have to digest some of this stuff before.
Okay, so we want to get started with the regular meeting and
We
then
have a 5-minute break.
come back and, yes?
Yeah,
Okay. All right, we'll take a 5-minute recess and then come back.
to the 7 o'clock meeting.
Correct.